Good day to all. I'm Advocate Pradeep Shukla, practicing at Bombay since 49 years. और अभी मेरे YouTube चैनल एडवोकेट प्रदीप शुक्ला पे सेक्शन 138 ऑफ नेगोशिएबल इंस्ट्रूमेंट एक्ट विच इज़ पॉपुलरली नोन एज ए चेक बाउंस केसेस एक अच्छा जजमेंट अपलोड करने जा रहा हूँ विच कैन बी बेनिफिशियल टू सो मैनी पीपल. दिस मैटर वॉज फ्रॉम द बॉम्बे and everybody knows that 138, though it is arising from civil transaction of, but under this act it is given a criminal effect where the accused is found that way guilty of not making payment. Then in that case he can be imprisoned also. Now, as a complainant, what complainant has to prove is that the check was given towards one legal liability and a notice was given for the payment after the dishonor of the check, and within stipulated period of 15 days the payment was not made. Then the offence is deemed to have been committed. He can file a criminal complaint. Now, of course, there is a provision of double the amount, and imprisonment is a discretion of the court depending on the facts of the case. But in this judgment, what is important is that it is made compoundable. Now, generally, the criminal offence in such a cases is not compoundable that way, because once the offence is proved and the accused is found guilty and the order is passed against the accused, then compounding such an matter even after the order of conviction is passed is as good as difficult. But under section 147 of Negotiable Instrument Act, there is a special provision that which overrides the Criminal Procedure Code. As per this, the court has a power to get the offence compounded even after conviction. In the present case, what has happened was that the check was bounced, the accused was convicted, against the conviction, and appeal was prepared. Appeal also the accused lost. Revision was prepared, revision also the accused lost. At that stage, both the parties compounded the offence and wanted to settle. The court was a dilemma whether what to do. The Bombay High Court has given a well-considered judgment that there is a provision under section 147 of the Negotiable Instrument Act which overrides the other provisions of Criminal Procedure Code, and even in the discretionary power of the High Court, the court can compound the offence. The compounding that offence was allowed, but this can be done only if both the parties, complainant and the accused, both have agreed. May looks very simple, but in many cases it becomes difficult that the trial court may not allow after conviction, may not allow the compounding of the offence. And that's why the matter went up to High Court. So just take note of it, that don't take the provisions of section 138 so lightly. It is always better to compound if genuinely there is a legal liability to pay. In that case, any person, because on my YouTube channel I have given so many judgments on section 138 which will be helpful to so many people. You can visit my site also, or if anybody has any questions they can definitely contact me. Thank you.